Case number 20-30767. Mr. McMahon, you have reserved 5 minutes for rebuttal, and you may approach the podium and begin on the 15 minutes you have to open.
Good morning. May it please the court. Michael McMahon and law partner Kirk Arant on behalf of Bonvillian Marine Services, the appellant in this matter. Just a quick backdrop of this case. This is a collision case arising out of a lesion case arising out of
I just want to show I knew the difference.
The Miss April, owned by my client Bonvillian, and the Sadie, owned by Baywater. As a result of that, Mr. Junior Pellegrin claims personal injury. Pellegrin filed a state lawsuit after this January 2019 incident in August of 2019. Bonvillian filed its complaint and limitation 4 months later. As with any limitation complaint, the claimants came forth, both Baywater and Mr. Pellegrin, and after that procedural process was complete, Baywater then moved to dismiss Bonvillian's limitation complaint, arguing that it was filed late, arguing that it should have been filed in the September time frame based upon correspondences between two adjusters in this matter. The court took the matter up and ultimately decided that it lacked jurisdiction on the basis that the time requirements in the limitation liability statute were jurisdictional in accordance with this court's holdings in both Eckstein and R&B. That decision then played an impact on how the court analyzed the evidence thereafter. Simultaneously, Judge Vitter recognized that Bonvillian made a compelling argument based upon the Wong case that the timing requirements of the Limitation Liability Act were in fact not jurisdictional, and that is exactly why we're here today. The issue before this court is, did Wong explicitly or implicitly overrule R&B and Eckstein? Bonvillian argues, arguably it explicitly did, and certainly it implicitly did. In the Eckstein case, the court has held that the Limitations Act 6-month filing on requirement is in fact jurisdictional. This court relied upon the In re FEMA trailer case, which is an FTCA, Federal Tort Claims Act case. In the Wong case, the court abrogated the FEMA trailer case and also set out guidelines, tests, in order for any court to be able to determine whether or not these timing deadlines were jurisdictional or non-jurisdictional. As the court may recall in the Eckstein matter, it noted this problem or foresaw this problem back in 2012 when it stated, although the Supreme Court has recently concluded that many filing deadlines are probably not jurisdictional, it has not explicitly or implicitly rejected this court's decision. That day, according to Bonvillian, has now come. And with regard to the implicit overruling of it, the Wong court set out a number of tests. The first being is whether or not Congress provided a clear statement that the timing of the filing was in fact jurisdictional. Now, the Limitation Act is pretty simplistic. It's 2 sentences. 1, allowing the vessel owner to file the limitation, and 2, setting forth a timeline. There is no language in the Limitation Liability Act to suggest that the 6-month time frame was in fact jurisdictional. So we argue that in that test and based upon that test alone, the limitation time filing lines are in fact not jurisdictional. The second test is whether or not the time deadlines only speak to timeliness. And that is in fact the case with regard to the second sentence of the Limitation Act that reads, the action must be brought within 6 months after a claimant gives the owner written notice of a claim. That only pertains to the timeliness. But if there's any dispute or concern that those two tests have not satisfied the court that the time frame is in fact non-jurisdictional, there's yet a third test, and that is whether or not Congress has separated a filing deadline from a jurisdictional deadline. As Judge Barksdale may remember, in the Guillory versus OMC outboard motor corp case, 956 Fed 2nd 114, 1992, where he was on the panel, the ruling was the Limitation Liability Act does not confer jurisdiction upon federal courts. Jurisdiction is conferred through 28 U.S.C. Section 1333. So far as the Wong guideline, we have a statute that gets its jurisdiction separate and apart from where the timing deadlines are contained. That in and of itself, according to the Wong court, establishes that the time constraints are in fact non-jurisdictional. I anticipate counsel to argue, but it says must. The Federal Tort Claims Act had two time deadlines. One said must, one said may. The Wong court said those type of statements, to include shall be forever barred, are not and do not carry the talismanic language necessary to invoke jurisdiction. It is Bonvillian Marine Services' position that the district court erred in finding that the limitation of liability timing constraints of 6 months were in fact jurisdictional. We ask this court to overrule that, but the importance of that decision played out in the rest of the court's rulings.
Counsel, let me ask you on the In re Brown case, which granted is an unpublished opinion, but it is post Hua Fun Hong. Why is there no mention? Wouldn't that have been an opportunity for the court to do as you argue here?
Yes, Your Honor, with one exception, if it was raised. It wasn't raised. We have cited on page 2 of our reply brief that this court has found that an opinion restating a prior panel's ruling does not sub silentio hold that the prior ruling survived an uncited Supreme Court decision. I would suggest that this is this court's first opportunity, notwithstanding Brown, to rule on this jurisdictional issue. The court has, in the Trinity Marine case, evaluated the Wong analysis and applied that in overruling the district court in an FTCA case. Again, it comes back to FTCA. In FEMA trailer was FTCA, and it's since been abrogated. The importance of this framework is the burdens of proof that come with the decision as to jurisdictional or not. And once Judge Vitter found that it was jurisdictional, she then applied a 12B1 burden of proof, giving all the inferences to Baywater, weighing the evidence in front of Baywater, when the Trinity Marine case says in non-jurisdictional issues, the motion should be treated as a 12B6 motion or more in like of a summary judgment motion, in which, in that case, Bonvillian would have been granted the inferences.
I know the various rules of the Wong decision, et cetera. Here, we're not writing on a clean slate, of course, because we have prior Fifth Circuit precedent saying it is jurisdictional. So we have to sort of run this through a filter. It's not just a one-part test. It's sort of a two-part test. The loyalty, deference, preference, whatever you want to call it, of the rule of orderliness that we adhere to in this court. So how do you factor that in? How can you say, well, you got clear sailing here, no pun intended, because even though you do have the rule of orderliness in your court and you strictly follow it, you can get past that because?
Because since Eckstein, the law has developed through the Wong case. Other circuits.
Well, for example, you could say, well, Wong was the FTCA. And yes, Eckstein, referenced to FTCA case, but Eckstein wasn't FTCA, et cetera. I mean, so I'm just asking you, if you were sitting here, how would you get around the rule of orderliness other than, yes, it's been an intervening change in the law?
I would apply, Your Honor, the test and the guidelines as set out in Wong to the Limitation Liability Act and its limited congressional history, considering it dates back to 1851. Counsel has suggested that it just go up to the United States Supreme Court and let them decide. Bonvillian disagrees with that. Bonvillian believes this court can, in fact, analyze Wong, analyze the Orion opinion in the 11th Circuit, and recognize that this jurisdictional issue has developed since Eckstein. Once we look at the burdens of proof, that gets into the other errors that the district court made with regard to written notice to the vessel owner. As the court is aware, there are about 5 emails between February 19th, 2019 and March 26, 2019 between 2 adjusters. The law is very clear that the written notice must go to the vessel owner. There is absolutely no evidence in the record, nor will be there today, that Bonvillian Marine ever received actual notice. Now, the workaround. I expect argument to be, well, Jerry Carney said he was a principal, Jerry Carney said he was representing Bonvillian. The RLB contracting case directs that presumptive notice is insufficient for purposes of actual notice under the Limitation of Liability Act. Baywater would like this court to presume Jerry Carney was in communication with Ann Bonvillian and presume that Jerry Carney was forwarding emails to Bonvillian Marine and presumed many other things that Bonvillian Marine needed to know in order to be put on written notice. The first written notice in this case to Bonvillian when it was served with the lawsuit filed by Mr. David Bateman on behalf of Pellegrin. That's when the timeline starts. And there are a number of limitation cases out there. Many of them start the timeline with the notice of lawsuit. Can there be exceptions? Yes. But the cases cited throughout the briefs suggest a number of factors in each of those cases. One, lawyers involved early on in the matter. Mr. Tompkins and I were not involved in this matter, at least that I know of, in the March 2019 timeframe. Massive injuries and or deaths, like we recently saw in the Secor casualty. Letters specifically to the owner. And the final factor, an owner giving direct and apparent authority to a claimant to deal with an adjuster. That does not exist in this case. There is no evidence to that effect, and because the court did not consider this a summary judgment motion, that was an error on behalf of the court.
All right. Thank you, Mr. McMahon. You have 5 minutes for rebuttal. We'll hear from Mr. Tompkins at this time.
Good morning. Thank you, Your Honor. May it please the court, my name is Peter Tompkins, and along with Taryn Walsh, we represent Baywater Drilling, LLC. Also at counsel table is David Bateman, who represents Junior Pellegrin and his wife. We are here today to seek an affirmance of Judge Vitter's what we consider to be well-reasoned decision with respect to whether or not Bonvillian filed its limitation complaint timely, when in February and March, clearly there were emails directed to an individual who was stating in his emails to represent Bonvillian, a claims adjuster, putting them on notice that this man was injured, putting them on notice that Baywater, as his employer, and who owed a maintenance and cure duty to a man injured in the service of his vessel, would be paying maintenance and cure, and that they would be holding Bonvillian responsible. Those emails also contain substantial discussions about the loss of income to Mr. Pellegrin. They talk about and they attach medical records that show that he had a herniated disc, that he was getting ready to have a lumbar epidural steroid injection, and if that injection failed, he was going to be a candidate for surgery. Why are those emails important? Because the test for the employer as to whether or when he has notice, is it reasonably possible, not reasonably probable? Does the employer know of a reasonable possibility of a claim that will exceed the value of the vessel, in this case the Miss April, valued at $328,000 by their surveyor? As this court is well aware, a Jones Act seaman who is injured in the service of the vessel due to the negligence or fault of a third party like Bonvillian here, who undergoes back surgery and loses those wages and has pain and suffering for back surgery, that claim certainly, possibly could exceed the value of the vessel. This is undisputed evidence in the record, even if there's a summary judgment standard, which we'll get to as part of this argument, but it's undisputed that Mr. Carney had knowledge of all those facts as early as February or March at the latest. Certainly in early March he had notice of all these facts, which would tell Bonvillian that they had 6 months from that time to file their claim, which would have been well before the December filing of their limitation, which, as counsel pointed out, was just a few months after the filing of the lawsuit.
Counsel, suppose we agree with everything you just said, and that there's undisputed evidence of the notice, and that therefore, under a Rule 56 standard in summary judgment, that your client prevails. What would be the judgment if that were the relevant legal standard in resolution of the application of law to fact? What would the district court do?
District court would dismiss the limitation action.
With or without prejudice?
The limitation action would be dismissed with prejudice.
With prejudice, exactly, because it would be after summary judgment.
Yes.
Right, and that would be true under any Rule 56 case, right? In any Rule 56 case, say that, take a prototypical civil action, there's a year of discovery, there's depositions and RFAs and interrogatories, and everybody litigates it, they file their motions of undisputed fact, the district court agrees with your client, the defense in this case, and dismiss the plaintiff action with prejudice. That would always be true in Rule 56, right?
I can't think of a scenario where it would not be true. The unusual thing of what we're dealing with here, though, is a limitation action is effectively a defense mechanism that a vessel owner employs. So what would be dismissed is his ability to assert that limitation defense through the federal action.
Yeah.
Right?
Like there's no way he would ever be able to re-raise 30511A.
Correct.
So it would be with prejudice.
It would be with prejudice, and then the case would revert to state court where it was filed in the first place.
Right. So if you look at the judgment that Judge Vitter entered at page 347 of the record, is it with or without prejudice?
I believe it was without prejudice.
So how could we affirm it? Even if we agreed with every word you just said, how could we affirm it?
Well, maybe the court, under its de novo rights, would have the ability to declare it dismissed with prejudice.
Do you think we could do that?
That issue, to be honest with you.
So you're not familiar with a case where we've ever done it?
I'm sorry?
You're not familiar with a case where we've ever done it?
I can't say that I've looked at that issue, Your Honor, to be honest with you. My humble opinion, and Judge Vitter would have to be the one to say this, is it's without prejudice to the rights of them to pursue all their other defenses to the claim, and for Pellegrin and us to pursue our claims in state court. I assume that's what she meant when that was written, but...
Well, it's without prejudice because every 12b1 dismissal is without prejudice, right? If jurisdiction never attaches, the court has no judicial power to do anything. So as a consequence, every 12b1 dismissal by rule is without prejudice. So it's not like she had discretion one way or the other. If she's granting it under Rule 12b1, it's without prejudice.
Which I guess flips us back to the first part of the question, which is this a 12b1 matter or a 12b6 matter?
So, exactly. But if you can't affirm a without prejudice dismissal using the Rule 56 standard in summary judgment, then it strikes me that your entire position in this appeal hinges on whether we have to overrule our prior cases interpreting 305.11a as jurisdictional.
Yeah, Your Honor, I mean, I frankly have not thought about that. It's a little more esoteric than where I've set my sights for oral argument today. So I wish I had looked at that more to talk more intelligently on that point. But turning, Judge, to the court to the issue of Wong, Wong has been pointed out, is a Federal Tort Claims Act, and says that the statute of limitations in that is non-jurisdictional. The significance there is the question was, can you toll the statute of limitations, or could it be equitably tolled? And the discussion was had whether it could or couldn't be, and the big issues, as I read the case, are that while most time bars are non-jurisdictional, when the time bar is separate from the jurisdictional grant, that's a big indicator that it's non-jurisdictional. Here we say that the time bar is directly within 3511A, and as counsel points out, we do think it's significant, not the sole issue, but it's significant that the action must be brought within 6 months, must be brought. Courts have clearly said that that language alone doesn't mean it's jurisdictional, but that's a factor we think to look at. As I said earlier, the Limitation Act is a defense, and it's something that vessel owners can use strategically in that fashion to, in fact, file their lawsuit. They could theoretically do it the day after the accident. And if they do that, and the court puts a quick monition date of, say, a month or two after the accident, claimants are forced to come in within 3 months when they normally would have 3 years. We think this makes the Limitation Liability Act different than a traditional, time bar, like say in the FTCA cases, where it's a claimant trying to toll the statute of limitation. This is an employer vessel owner trying to, or a vessel owner I should say in this case, trying to gain the benefits of that statute that has a 6-month mandatory filing period. We think that distinguishes our case from Wong, and to Your Honor's point, in order for a Supreme Court decision to change our circuit's law, the case must be more than illuminating with respect to the issues before the court, but must unequivocally overrule prior precedent. That would be the Liberty Surplus case that we cited at page 14. We do not agree that the Wong case unequivocally overrules this. In fact, as the court has pointed out, Brown case, which is 2019, several years after Wong, had the opportunity to say that and did not. RLB Contracting and the Eckstein case both clearly say that it's jurisdictional. So with this court's longstanding precedent that it's jurisdictional, we do think Judge Vitter correctly ruled that the 12B1 motion was the way to go. Certainly from our standpoint in filing it had to be the way to go because that was the rule of this court. And we think that as such, for the reasons cited earlier in discussion about the notice given to an individual who is a claims adjuster and represents Bonvillian is adequate. And just on that point, I think it's pertinent to review arguments made at the oral argument where Judge Vitter asks Bonvillian's counsel, so you're acknowledging that Mr. Carney represented Bonvillian? And he says, Your Honor, I acknowledge he represented them for purposes of handling the claim. I do not accept, as there is no evidence he was appointed by Bonvillian for purposes of notice for limitation of liability. That's at page 384. So he's acknowledging that he represented him for purposes of handling the claim. And later at page 405 of the record, the question is, does Mr. Carney represent Bonvillian? Answer, so far as early claims handling aspect of this, the answer is yes. But for purposes of statute of limitations, the answer is no. I think this admission by counsel that Mr. Carney was the agent is significant, and the case law is clear that an agent can receive notice for a limitation, and to try to say that he can be an agent for purposes of claims handling and making all the inquiries he's making as far as what's this claim status, what is this man doing, how are we going to work together to resolve this claim, that he has all that inherent authority as an agent, but yet if we tell him we're putting you on notice, that we're going to hold you responsible, he doesn't have that authority, just seems counterintuitive. I think the admission that he is their agent in the Orion case, while not a Fifth Circuit case, is specifically on point with that, where a FARA, F.A. Richard adjuster, was found to have claims handling authority. He also could get the notification that the lawsuit, that the claim had been made, and thus trigger the tolling of the 6-month limitation period. So I have more time, but those are the big points that I wanted to make. I think that the jurisdictional nature of the challenge is clear in the Fifth Circuit and has not expressly been overruled by Wong, and that the evidence that we presented clearly establishes that Mr. Carney had the authority he needed to act. We were justified in presenting the claim to him and putting him on notice, and that they therefore should have filed their claim within that 6-month window, not after the lawsuit was filed, and the failure to do so means that Judge Vedder was correct in ruling that the case should be dismissed without prejudice. Questions, Your Honor?
Thank you, counsel. Mr. McMahon, you have 5 minutes.
Thank you, Your Honor. I'll address Mr. Tompkins' last point, and that's with regard to the authority of Mr. Carney. And by no means was I trying to be cute or coy with the court. I was following the law of this circuit, namely Diamond versus Brutel, 247 Fed 2nd 604, 1957, which held there's nothing preventing the owner from appointing an agent. There's absolutely no evidence that Bonvillian appointed Carney. Baywater would like you to presume that, but there's absolutely no evidence. I believe, I had a little hard hearing him, but he was making reference to the Orion case of the 11th Circuit for apparent authority. However, even the Orion case at Head Note 7 says the manifestation that gives rise to authority must emanate from the principal. In this case, that would be Bonvillian.
I didn't know we relied on head notes.
Apologize, Your Honor.
Not being cute, I just...
No, that was just my reference. And I don't believe I stated this. If I did, I apologize. But the few emails, Bonvillian Marine, in any form or fashion, is not listed as a CC. The CC, who Mr. Carney was reporting to, is Michelle Terrebonne at Allianz, very well recognized as a marine insurer, not a vessel owner. With regard to the emails and what they purport to say with regard to valuation, Baywater conflates those. They are from February 19th to March 26th. They reference maintenance and cure of less than $4,000. Mr. Tompkins would like to argue that they project a back surgery. That's not what they project. They project a man who goes to see Dr. Sinek and on physical examination is 100% normal regarding the lumbar spine. There's reference to a surgery possibly in the future, but in the time frame, the limited time frame of the emails, there is not and cannot be a suggestion that this claim is going to blow up beyond the $328,000. And what is particularly bothersome is Mr. Carney on March 26 states to Shirley Bigford that he would like to have the information before making a decision. That is the last evidence about this claim in the record before Mr. Pellegrin got his surgery after he filed lawsuit. Baywater wants to hook Bonvillian on emails about what this case may have been worth about, but stop providing the information such that Bonvillian could make the decision. When you look at this in a 12b6 analysis with the inferences in favor of Bonvillian, it doesn't pass summary judgment standard, particularly on the genuine issue of material fact, of which Baywater suggested to Judge Vitter discovery may be needed. With that, Your Honor, Baywater 12b1 motion was premature and improperly granted by the district court. Bonvillian respectfully requests that the district court should be reversed, and this matter should proceed with the limitation timelines as non-jurisdictional, still affording Baywater the affirmative defense after there is discovery on the motion. Thank you for your attention.
Thank you, Mr. McMahon. Counsel, thank you. We'll take the matter under submission.